Okay, so in this week we'll be discussing real and personal property. So this is, for example, if you're purchasing a home or you're purchasing a car. By way of outline, we'll first discuss real property and what that means, and these are things like real estate, things land essentially. And in the second part we'll discuss personal property, and we'll note the differences between these two types of tangible property. So things you'll need to consider is the nature of ownership of real and personal property. So the legal relationship and the obligations that accrue from ownership of these two forms of property. How you acquire and transfer title to the property, and this becomes actually very important in business because when title is transferred is also when risk is transferred as well. So that's very important for us to appreciate also. We'll also look at how mortgages work and when you go to purchase your home, what are the things that are involved there. And then if at the current stage that you're in, whether you are leasing a property or renting a property, what are the rights and obligations of the landlord vis-a-vis the tenant? And how what happens if, for example, the tenant doesn't pay rent, and what can the landlord do? So we'll start by looking at the categories of property in very broad terms. This week we're discussing tangible property. So these are things that you can actually touch. So personal property, it comes from its physical form. Now increasingly in the information technology age, we are dealing much more so in intangible properties, so the products of the mind, you might say. The personal property comes from is entirely created through legal rights. So if you think of patents, copyright, all of those are actually legal concepts, and if it were not for the law, you would simply not have these businesses in operation. And so intangible property we'll take next week's class. So today we'll focus on tangible property, and in this class we're looking at real property. So acquiring ownership of property, so we all own things, and how we can acquire ownership in a number of different ways. So with land, for example, you can acquire it through purchasing or leasing the land. You own it in terms of a specific time period, or you can purchase manufacturing goods. Those are forms of personal properties. But you can also think of property in even more broad terms of, for example, accounts receivables, when you may get paid for the item at a future date. Certain forms of intellectual property, these slides, for example, are copyright protected. They come into existence, that property comes into existence the moment it is created. It's a very unique idea that is created entirely through the operation of law. Our focus today is on real property. So we need to think about what real property is. Now, real property in law is referred to as land or real estate. So these are buildings, fixtures, and the associated rights associated with the land. So, for example, you have to appreciate that fixtures or things that are attached to the land form part of the land itself. It doesn't move at all. Now, the thing to appreciate about land is it's permanent, immovable, and its quantity is limited. That is very significant for us to appreciate because the laws that have developed in order to deal with ownership of land reflect this fundamental fact. You'll see, for example, when you purchase a home, it's that plot of land which is very unique, which you have intended to contract for. Under those circumstances, the remedies are for if the contract is breached will be specific performance. That is to say, you will get that particular land. It's not money that you actually want, it's that a portion of land because it doesn't exist anywhere else. Now, land is owned in many different ways, and we need to appreciate the different various interests in land. The best form of land ownership is known as fee simple or fee simple absolute. Here the legal interest is the closest form of full ownership. So this is where you can do whatever you want with the land, but it's not exactly whatever you want, as you'll see, because all land comes with certain restrictions which are placed upon it by the municipality, by the provincial and indeed the federal government, as we've discussed in the first set of lectures. But fee simple is where the landowner has the most rights associated with his or her land ownership. This can be contrasted to different forms of dividing land ownership. So you can own a plot of land together with somebody else, and if you are owning that land where in a tenancy in common, as it's known, each individual will own their portion of the land, and they can dispose of that. They can sell that land as they see fit. That can be contrasted with a joint tenancy, where the survivor inherits the undivided interests of the decedent, the person who dies. So typically, if you are married, you will own the land, own your home in a joint tenancy. The reason for this is if the spouse dies, the surviving spouse will get the land. It automatically gets transferred to them. Whereas a tenancy in common, for example, is typically used in business. Three partners join together and purchase a property. If they want to get out of that business, they can sell their portion of the land as they want, because they are holding that land in a tenancy in common. That's not possible with a joint tenancy. You can also divide land ownership in terms of time. So, for example, if you are renting a property, you rent that for a specific period, typically a year. Under those circumstances, you are in fact a landowner. You're a landowner for that particular period, and you are treated as the landowner under those circumstances. Even though there is somebody else who owns that land, you can exclude their access for that period because you've paid for that right. Now, as I mentioned, even in the fee simple scenario, there are plenty of restrictions on your use of the land. So the municipal government places restrictions on, for example, how high you can leave your grass before cutting it, for example. Environmental regulations restrict you from pouring oil onto your lawn, for example. You can't necessarily play loud music all the time in your home because of the laws of nuisance. And in fact, it is the case that the government can always expropriate your land, and under those circumstances, it will compulsorily purchase your land in order to, for example, extend the 407. It's also the case that foreign ownership can be limited by the government as well. So if there's certain plots of land, for example, that the government doesn't want any foreign, they want to retain that as Canadian-owned land, that can be restricted as well. Now, if you own land, you can place encumbrances or restrictions yourself on the land that you own. When you are a landowner and you rent your property, you are creating an encumbrance of a lease. So when you grant the lease to the tenant, you are giving that tenant the right to occupy the land for a specific period of time. Similarly, a mortgage is also regarded as an encumbrance in law. With a mortgage, you are essentially using the land as security for the loan that you are making. Other forms of restrictive covenants, other forms of encumbrances are easements and restrictive covenants. An easement is a right to use the land for a specific purpose. So, for example, the municipality will typically have an easement or right of way to access your property to, let's say, for example, clear a drain. For example, you cannot deny them access because they have an easement. They have a right to access your property under those circumstances. If, for example, you live in a historic building There may be restrictions on what you can do to the front of or the facade of your home, for example, because it's labeled or restricted for particular for historic purposes. You can also, for example, in your title, have restrictions on certain activities. You cannot cut the trees bordering your neighbor, for example. All of those things are known as restrictive covenants that restrict the landowner's use of their land. Now, when you're typically trying to purchase land, you will have to consult the land registry system. Now, as I mentioned, land has a unique quality in that it's permanent, immovable, and unique. And because of this, there is a comprehensive system of land registration where you can determine who has owned that property prior to you. And this is an area of provincial jurisdiction, so that it occurs within the province. Now, in Canada, what happens is that once you purchase land, and land must be purchased through a written document, is covered by the statute of frauds, as we learned in contract. You have to consult the registry system and examine who are the interested parties. If there's a mortgagor, if there's somebody who has loaned you money to purchase that house, that name, the name of the bank, will typically be entered into the registry. There is a land title system, and that is essentially a guarantee or insurance that the title that you acquire from the registry is in fact the true ownership. And so there's a very strong incentive to make sure that those records are in fact accurate. And this makes sense, of course, because if you were uncertain as to who you were purchasing the property from, it would make purchasing land very, very difficult indeed. Now, the purchase of land is in fact a situation of caveat emptor, or let the buyer beware. So you as a buyer have a duty to investigate and evaluate the property in terms of both the financial and the legal risks involved. And this is why you're going to hire a lawyer as well as a real estate agent to assist you in the purchasing transaction. Now, sellers do have a positive duty to disclose any latent defects. So if there's something wrong with the property, if there is structural defects that are not easily visible, that are known to the seller, they have to disclose that. But it's not the case that they have to disclose everything. So it is a bit of a gray area. But typically, it's the case if there are significant, and by significant we mean structural typically, or fundamental, that are known to the seller at the time of the purchase that make the property dangerous or otherwise uninhabitable, such as termites, for example. Those things have to be disclosed. There's quite a bit of terminology you need to know about mortgages. So a mortgage is a credit arrangement for the security of loan. We need to know about the land title system and the registry system. Equity redemption occurs in relation to purchasing or acquiring granting a mortgage in your property. When you grant a mortgage to your property, you are essentially owning the property with the bank. Now, as long as you keep your payments on your mortgage, you have the right to regain the legal title to that property once you've repaid that mortgage debt. Now, you, as the person taking out the loan, is referred to as the mortgagor or the borrower. So you are granting a mortgage to the mortgagee, the bank, in order to purchase your properties. You're entering into a long-term payment arrangement, sometimes 25 years, for example. The mortgagee is the person who is waiting for their money. For example, the lender. They have a number of different remedies if you don't pay. So they can foreclose on your property, they can sell your property because they're sort of part owners of your property in a way. Their remedy can be to terminate your interest in the property and sell the land to satisfy their debt. Deficiency refers to a shortfall that occurs between the outstanding mortgage balance and the proceeds from the sale. So let's say, for example, you've purchased your home for $100,000, but actually the market has been depressed, and now your property is actually only worth $80,000. You're still on the hook for the $100,000, in fact, and so the deficiency here, or you have a negative equity situation of $20,000 actually, and that has been a major problem actually in recent times with the financial crisis. There are some other terminology in relation to leases. So the tenant is the person who is going to be in possession of the land that is leased. The landlord is the person who grants that right to the tenant. With a lease, it's a contractual arrangement where you're transferring possession of the land, but not ownership of the land, to the tenant in exchange for the payment of rent. Now, if you have a lease, you have exclusive possession of that property. Once you close the door, the landlord cannot simply enter at will. So you have a right to control that land, and that actually affects your tort liability as well, because you are in fact controlling or the occupier of that land actually. And the landlord has to refrain from interfering with your quiet enjoyment of that property since you've paid rent. However, if you don't pay rent, there are rights that the landlord has, and ultimately in the commercial setting, one of these rights is the right of distress. So the landlord can go in and seize planned equipment, for example, for the non-payment of rent in certain circumstances. You can terminate a lease when the payment period has expired, so that's termination by performance. But for example, let's say you are at the end of your lease and your year is up, but you're still in the property, you've had no other agreement, but you're still continuing to pay rent. You're paying rent on a monthly basis. Now what happens is it's not the case that because there's no contract that governs your occupancy of the property that the landlord can simply turf you out at will. What happens then next is you have a periodic tenancy. That means that for every month or the payment period, your lease will automatically be renewed, and the landlord will have to give you at least a month's notice in order to terminate your use of the property. So landowners have a number of different rights. They can use their land for security of a loan by granting a mortgage. They can lease or all or part of their land to tenants, and they can transfer the land to others through joint tenancy, for example. And they also have the right to sell all or part of the land. So lots of different rights and obligations that are associated with the use of real property. That's it for this class, and I'll see you in the next session.